Thank you for joining us for today's discussion. My name is Lisa Geller, and I am the State Affairs Manager at the Educational Fund to Stop Gun Violence and the Coalition to Stop Gun Violence. My work focuses on advocating for and implementing gun violence prevention policies at the state level, with a focus on extreme risk and domestic violence protective orders. For those who are not familiar with us, the Educational Fund to Stop Gun Violence, the Ed Fund, and our affiliate organization, the Coalition to Stop Gun Violence, CSGV, use a public health and equity lens to identify and implement evidence-based policy solutions and programs to reduce gun violence in all its forms. We've been making communities safer since 1974 by translating research into policy and engaging with community stakeholders to advocate and implement these policy solutions. Our years of research have shown us that collaborating with partners in states across the country is the best way to end our national epidemic of gun violence. That's why I'm thrilled today to partner with Ceasefire PA for today's discussion. Our expert panel will discuss the importance of passing an extreme risk protection order in Pennsylvania. Extreme risk protection orders, also called extreme risk laws or ERPOs, are law in 19 states and DC. Most of these laws passed after the 2018 Marjory Stoneman Douglas High School shooting in Parkland, Florida. Extreme risk laws empower law enforcement and, depending on the jurisdiction, family members, healthcare professionals, and school administrators to work with courts to temporarily remove firearms from those who pose a danger to themselves or others. Evidence shows that extreme risk laws are effective in preventing suicides and homicides and have even been used in efforts to prevent mass shootings. The first extreme risk law was Connecticut's risk warrant law, which passed in 1999 following a mass shooting at the state's lottery headquarters. 6 years later, in 2005, Indiana passed another early version of an extreme risk law. Both laws only allow law enforcement to petition for a warrant. Extreme risk laws were further developed from risk warrants to the protection orders that are common today by the Consortium for Risk-Based Firearm Policy in 2013. Following the Sandy Hook Elementary School shooting in Newtown, Connecticut, a case in which a risk warrant was not sought, the national conversation around preventing gun violence focused on mental illness. To examine the potential relationship between mental illness and gun violence, the Ed Fund, led by our executive director, Josh Horowitz, brought together the nation's leading researchers, practitioners, and advocates in gun violence prevention, public health, law, mental health, and others to form the Consortium for Risk-Based Firearm Policy, also called the Consortium. Though they are separate entities, the Consortium is organized and staffed by the Ed Fund. The Consortium convenes regularly to develop evidence-based gun violence prevention policies, and in turn, these policymakers have come to rely upon the Consortium's recommendations to craft legislation and executive action to inform implementation efforts and to continue to shape the policy landscape for gun violence prevention. Though best known for its development of ERPO, the Consortium has published reports on evidence-based recommendations for other state and federal policies, best practices for firearm removal in cases of domestic violence, and guidelines and practice for training in lethal means safety counseling to prevent firearm suicide. We'll be sharing the link to the full ERPO reports in the chat, but the new report outlines state-level recommendation for the following areas for extreme risk laws: the duration of these orders, third-party or joint occupancy clauses, cases involving minors at risk of violence, petitioners, submission of records to the National Instant Criminal Background Check System, and data reporting and availability. We recognize that not all state ERPO laws have these components, and not all 2021 ERPO legislation includes these components, but these are best practices by the Consortium. So I'll start briefly going through these. The duration of orders, it's recommended that temporary ERPOs should be in effect for 2 to 3 weeks, while final ERPOs should last a year. Third-party clauses, in cases where firearms belong to someone in the home other than the respondent, it is recommended that it should be unlawful for any legal firearms owner to knowingly, recklessly, or negligently allow individuals under an ERPO to access these firearms. Minors should be eligible for extreme risk laws, regardless of whether they have legal access to firearms. Petitioners should include law enforcement, family, household members, and intimate partners, and licensed healthcare professionals. States should require a state-designated entity to enter ERPO information into the background check system so that people, ERPO respondents, are ineligible to purchase firearms. And states should assure that ERPO case data are entered into a centralized database and should facilitate access to these data for research and policy purposes. It's because of existing data on ERPO use nationwide that we're able to assess the efficacy of this law. I am very excited to introduce our expert panel for today's event. I will start with my colleague, Lauren Footman. She's the Director of Outreach and Equity at the Educational Fund to Stop Gun Violence and the Coalition to Stop Gun Violence. We're also joined by Dr. Jack Rosell, Medical Director of Resolve Crisis Services of UPMC Western Psychiatric Hospital. He's also Associate Professor of Psychiatry and an Adjunct Professor of Law at the University of Pittsburgh. Lee Wagner is a veteran from Murraysville, Pennsylvania. Taylor Kleffel is the Manager of State Policy at the American Foundation for Suicide Prevention. And last but certainly not least, we have Chris Carita, a detective in South Florida and also a Bloomberg Fellow at the Johns Hopkins School of Public Health. Before I turn things over to Adam, I would like to thank the Joyce Foundation for supporting this critical work. It's because of their support that we're able to put together forums like this. So I will now hand it over to Adam Garber, Executive Director of Ceasefire Pennsylvania.
Thanks, Lisa, and thanks so much, everyone, for joining us today. It's really great to be with such an amazing panel. For those that don't know, Ceasefire PA is the Commonwealth's only statewide gun violence prevention advocacy group. So we educate the public about the dangers of gun violence and solutions like extreme risk protection orders, organize them to advocate for solutions in the legislature at the local and at the national level, and then push for those solutions to be implemented. Through our history, we've helped protect individuals through disarming abusers, defend communities' ability to pass their own protections, and have been a longtime advocate for extreme risk protection orders. When we talk about violence here and gun violence in Pennsylvania, gun suicides are a large part of the problem. We lose about 1,600 people to gun violence in the Commonwealth every single year. And the vast majority, about 900 of those losses, are due to gun suicide. It's also worth noting that a significant portion of those suicides happen in our more rural communities and tend to be older white men. When we look at the data, what we find is some of the highest rates per capita of gun suicide, inclusive places like Wayne and Elk County and Cambria County and Towanda and others, in those areas that are outside of our major urban areas, which need other solutions to address them. It's why Ceasefire PA brought together earlier this year a new coalition of over more than 100 faith leaders, doctors, veterans, community advocates, survivors, and more to advocate for a common agenda to end gun violence. 3 policies look at the full sweep of the problem. They include extreme risk protection orders, along with lost or stolen mandatory reporting to deal with illegal firearm trafficking, and universal background checks to close one of the holes in our system that allow the purchase of long guns like rifles, private seller to private seller without a background check. These solutions will help reduce the gun violence problem. Here in Pennsylvania specifically, when we look at the state of the land, what we know is that there's not a good solution after someone already has access for a firearm to get them the help they need before they might take their own life. Once a weapon is sold, there's only really one solution at stake here in Pennsylvania to get that weapon out of their hand if they're going through a crisis and at risk. And that's a 302 process, it's known, which is an involuntary commitment through the mental health system. Unfortunately, while that is necessary at times, it may not always be necessary. And in fact, some people will not use that solution because once you've had a 302, you are almost completely prohibited from owning a firearm for the future. But that crisis may have passed. And that's really where I think extreme risk protection orders in Pennsylvania provide a huge opportunity. They provide an opportunity for loved ones or law enforcement, both who could implement one in the state if the law passes, to temporarily take away someone's firearm while they get the services and the help they need before violence happens. And that's what we're talking about, getting people the help they need before it is too late. It's why a bipartisan group of legislators led by Representative Todd Stevens in the State House, who I believe has joined us today, and Senator Fontana in the State Senate, who I think has also joined us today, have introduced legislation to establish extreme risk protection orders. Unfortunately, despite the clear evidence that these solutions work, we've yet to see them move forward into the General Assembly. And we're hoping through today's discussion and the knowledge you have that the people that have joined us today can help us change that dynamic. With that, I'd like to start with Dr. Jack Rosell. Dr. Rosell, you've been studying gun suicide and these sort of solutions for a long time. So what does the data tell us about the link between gun violence and mental illnesses and the ownership of firearms?
Right. So Most violence that's out there has nothing to do with mental illness or people living with mental illness. The intersection is actually relatively small. When we look at people who are released from, high acuity psychiatric settings, the vast majority of them do not go on to engage in gun violence. And again, when we look at people who've engaged in this, they don't have that history. Suicide is our high risk intersection. In Pennsylvania, like most states, half, maybe a little more than half of our suicides are related to firearms. And that rapid access to a firearm means that someone can translate those suicidal thoughts or impulses to a near lethal outcome almost instantaneously, within the reach out of the firearm. That's how quickly it can happen. And we know, and we have really good evidence that if we can sort of block someone's access to a firearm for a brief period of time, they don't go on to other attempts. Now, I do want to go back, Adam. You mentioned something earlier that what we have in Pennsylvania is the 302 as a way to take away firearms. Here's the damn thing, right? It puts someone's name on that can never purchase a firearm again list. It doesn't actually remove their firearms. That person has up to 60 days to voluntarily sell, transfer the ownership of those firearms. And I can tell you that's a really dangerous 60 days right after someone's had that intense intervention. What I like about the ERPO intervention is it has surgical precision. I learned in med school that gunshot wounds are tough to treat. And I learned in law school that the Bill of Rights is there for a damn reason. And ERPO lets me go in and say, for a brief period of time, with judicial objective review, I'm going to limit someone's access to firearms without having to do this sort of broad brush of indefinitely, interminably, they will lose access to their Second Amendment rights. And I like that precision. I like being able to use that precise of a tool.
I think that precision is really important. I want to go back to an important piece because one of the things we hear sometimes is that when it comes to extreme risk protection orders, that immediate removal, right, is actually part of the objection we hear on the other side. But it seems like you're saying that's actually almost the most critical time for the removal of firearm to save someone's life before it might be too late.
Absolutely. Whether it's suicide risk, whether it's violence risk, our ability to limit someone's access to lethal means is very important. Yes, there's a subset of people who switch methods when we're concerned about suicide risk. And if someone is thinking about engaging in violence towards another target, there are other ways to do it. But firearms are incredibly lethal and incredibly easy to use when you want to use them lethally. And so whatever we can do to mitigate some of those risks, we want to do it.
One of the things that's been talked about a lot over the last year is we've seen a huge increase in the number of firearms sold in Pennsylvania. Some estimates say 1.5 million firearms have been sold here in the state, right? And a lot of those owners we know through news reports and other analysis are actually first-time gun owners, right? We've heard that story a lot. We've heard it from the gun shops themselves.
Yeah.
Does that increase your worry or your sense of urgency in getting something like extreme risk protection orders implemented?
If you'd asked me a year ago, I would have said, we have this surge of firearms out to new gun owners. And we'd actually had recent research that came out a little over a year ago that says in those first weeks of firearm ownership, the risk of firearm suicide goes up about 100-fold, not 100%, but 100-fold. It's a huge increase. We haven't actually seen a huge surge in firearm suicides, thank goodness. We're still very concerned about that risk. What I will say is that whether you are very experienced with firearms or a complete noob, it's really hard to learn how to use a firearm safely and appropriately if you don't have access to the right kind of training. And that's something that we've actually had issues with over the past year because there have been so many new owners and it's been hard to go to the range and work with that good instructor and good trainer and to hear their firearm safety message.
Well, and I think, you're right. We actually haven't seen the rise yet in gun suicides and hopefully never will, though I know there's been other studies out of California that have shown the risk rate, for first-time gun owners actually exists for up to a decade later. And
yeah.
And even for people who maybe are well trained with firearms, we have those problems. And, when we talk about that, one of the most trained groups probably are veterans who go through the military process. And we have Lee here with us, a veteran and deeply trained and works with veterans on these issues. And Lee, what do you see when you look at, suicide risk and gun ownership around firearms and how that is playing out with that population that you're working with?
Thank you, Adam. I appreciate you being on and talking about this. it's a touchy subject in the veterans community in this day and age. As Dr. mentioned, veterans are a community that are very well trained and are extremely comfortable with firearms, with loaded weapons, and it's something that is part of a daily life for many service members. So it's a tough question to answer, I think, at times, because there's a lot of connection to the firearm and the owner. I think sometimes it's easy to say, we should do this for that. But on other panels and other conversations I've joined in and had conversations with, it's having a conversation with that gun owner, like, this is how we can do this to make you safer and others safer in the long term. It isn't just about making a decision one way or the other. It's really a touchy subject. I think it's the best way to. I know that's kind of a broad conversation or broad answer to your question, but I think these types of conversations with the folks who are in attendance today is really a great way to go, because that's where we're talking about risk, and when a veteran has a risk of self-harm, and they do have that access, as Dr. Roselle mentioned, limiting that exposure to lethal means, even for that moment, can positively impact and save that person's life. So I think the more we can have these conversations and break stigmas, I think is where it would be the most beneficial for the folks who we're trying to help.
Well, so when you're talking to a veteran about extreme risk protection orders and mechanisms to reduce the risk, right? How do you start that conversation, and how do you find ways into helping them understand how this can, reduce, make it more likely that they won't be at risk?
Yeah. I think Adam, we've talked about this. It's breaking the stigma, or having conversation around the stigma around suicide and self-harm. I think for the veteran space, they're so comfortable with firearms and so comfortable with weapons that it's more about what can a weapon do, and what type of mental state is someone in when they're thinking about taking their own life, and then having that easy access to that lethal mean. So I think I approach the subject not necessarily about the firearm itself, because I don't want a guard to go up, and I don't want, if I'm having some sort of intervention call, or, someone's called into our office or I'm just meeting someone on the street, which happens a lot in the veterans community, and we're having a conversation around this and self-harm. I be perfectly honest, I don't bring up guns. I don't bring up lethal means, because I don't know if that's someone who's very adamant about having their guns and very adamant about relinquishing any rights to their guns. Because I don't want a guard to go up and say, well, that's just something that's going to take my guns away. I want to have a conversation around where they at, where's their mental health state at, where do they know other veterans who are struggling, and really having a conversation around mental health, breaking stigma, and making sure that it's a character, it's a strength, it's a strength for someone to ask for help. It's not a bad thing for that older veteran or whoever to go ask for help. I want them to feel encouraged to do what's best for them and their family, to ask for help. And that means, and then from there, we have a conversation around, all right, what is around you that you could use to self-harm? And 90%, 100% of the time, whatever it is, I mean, being facetious, that veteran will say, well, I got multiple firearms in life. And okay, then we have that conversation. So it's coming at it from the mental well-being and the health, and then moving into the conversation around the actual firearm or what other lethal means they be available.
And so when you're talking to the veteran, or even maybe a family member, right? Because under extreme risk protection orders, mm-hmm. is written, right? It could be a family member who's worried about their loved one. You've talked about guns are, firearms are really part of veterans' often life. They hunt with them, they feel comfortable with them, they use them for protection. You kind of go through the list. And how do you, but the thing about the extreme risk protection order, right, is it's a temporary measure. So how Correct. Do you talk about that temporary aspect as a way to get them the help and then return the firearm to them so that they can continue on using it, however sure. they do it?
Yeah, and it's keeping them safe for now. I mean, we're talking to a family member, if that's the case, we'll have those conversations around what is available to them for self. And everyone's going to know what's in their house. They're going to typically know where the firearms are. And if someone is in a situation of self-harm, the family is going to be I shouldn't say this, but sometimes the family be well aware of what's going on in the home and what is around there. So it's a conversation around, let's keep this person safer now. Here's a way we can do it that doesn't have long lasting ramifications, because we want them to be happy. So yeah, to your point, if hunting and outdoors and going to the range brings them peace of mind and brings them, some balance in their life, who am I to judge? That's what they want to do. So here's a way we can find a solution to keeping them safer now, but also returning that piece of their life back to them as they, progress and move forward.
Yeah, and I think that's a great point. It's about protecting them now and then returning that to them eventually, at the appropriate time when doctors and experts and the judicial system can evaluate and make sure that they're no longer at risk in that moment. Taylor, I know you've been working with suicide prevention at the foundation for a long time and really thinking about these policy solutions here. And so when you're thinking about it, how do you see ERPO as a suicide prevention tool, and when do you think how often and when should it be used?
Sure. So I do want to emphasize, and Lee mentioned this, when we talk about firearms, we're talking about lethal means access as a more broad issue. We know that when someone's deterred from their initial method that they've planned, they often do not go on to try another method. So it's also why things like bridge barriers work. So that's a message we really try to push. And the other thing I want to make note of is it really is important about that 2 to 3 weeks. So the Indiana and Connecticut laws are the ones that have been studied simply because they've been in place the longest, and that's where we have the data. And we know it's not just that they were deterred from attempting suicide, but they also, many of the people who were stopped or a protection order was given to, got mental health services, got community services, and access that care. So we don't even necessarily advocate that then the order be extended a year, because it's really about that moment. And if someone can find the help they need within those 2 to 3 weeks, I think is the recommendations you mentioned, then that's the goal. And I forget the second part of your question. I'm sorry.
No, that's fine. I want to just touch on one thing for the audience. You used a term, and I want to make sure everyone's familiar, bridge barriers. And so can you just explain a little bit?
Sure. That can be anything from like fencing or netting, or it's basically what it sounds like. So it's something like the Golden Gate Bridge, for example. That's like a federal initiative because we know the suicide rate's high there. And it's another one of AFSP's priorities. My apologies.
That's fine. That's fine. Oh, yeah. No, now I got it. So I just want to make sure everyone knew. And then, when you, so what role, right? There's a lot of different work that y'all are doing to prevent suicides. What role do you think extreme risk protection orders should play in suicide prevention?
Yeah, so we really push that it should be voluntary whenever possible. So for instance, we partner with groups like the National Shooting Sports Foundation to get brochures out to gun ranges, to sellers, and making sure that they can share the educational materials. And that's kind of our first line of defense. It speaks to a lot of what Lee talked about with the culture. It's not just like when you talk about veterans or police officers who need a firearm for their job. It's more about addressing the culture and making sure they know. However, we know the biggest indicator that someone's going to die by suicide by firearm is that they have a firearm in the home. That's just, simply the way it is. So our goal beyond the education is the reason we started supporting ERPOs 2 years now as a tool is when voluntary efforts to separate an at-risk individual are just not possible or unsuccessful, and the suicide risk is imminent. We really wanted family members to have a tool to feel like they can help their loved one. But we do evaluate every bill very specifically. So like I talked about, we want to make sure there's that emergency mechanism for that moment of crisis. And then we also want to make sure that mental illness is not the reason or the sole reason for a risk protection order. So we kind of make a list of considerations that we recommend. So it's not just, it might be that they've had suicidal thoughts in the past. It might be that they've had struggles with depression, but really it should be about the behavior. So have they threatened themselves or somebody else? Have they had a protection or different kind of protection order, for instance, domestic violence? Things like that, and then the time and the age. So was it within the last year, not 10 years ago? And how old were they at the time? Things like that. It's really the behavior is the biggest indicator. And again, we really support this moreover, the 302, the involuntary hold, because A, we don't want people to lose their access forever, and B, we want to make sure that the firearms they have in their possession are taken away at that time. So we know they're safe. And then in that moment, that's when we get the mental health resources they need.
Yeah, and I think for all of us, we'd hope people would voluntarily remove the lethal means before it's too late. But we know, unfortunately, that that doesn't happen. And sadly, right, family members, I mean, I talk to so many family members who've lost someone, and you probably, you know, I think many of us do, and they wish they had a tool to take this action, and they need that to save the life of their loved one. And I think that's where we really think that this is an additional role if that voluntary mechanism does not obviously work out, but the education and the counseling ahead of time can be critical. I think you've, Taylor, moved us on to a little bit of the next piece of the discussion really nicely here, which is actually how do these get implemented? What are the criteria and what are the pieces that can go into the decision making? And what we want to do here is bring in Detective Karita and Lauren Footman, who've really studied some of the implementation, and Chris has really done implementation of extreme risk protection orders in Florida, and give them the opportunity. So I'm going to hand it back to Lisa to moderate the next part of the discussion, and then we're going to come back to Q&A. So keep putting the questions in. Promise we're going to get to a bunch of them, but we're going to come to that a little bit later in the discussion. Lisa?
Thanks, Adam. Yeah, great reminder for Q&A. We will get to that. This is a natural segue. Detective Karita, as Taylor mentioned, there are certain risk factors that have to be considered, and we don't want mental illness to be the consideration for why an extreme risk law is issued. So can you tell us a little bit about what you're seeing on a daily basis in Florida, and what risk factors you're using when you're going to issue an ERPO?
Sure. So the same concerns were on the minds of the legislature here in Florida when they passed the law. They didn't want it to be redundant with our involuntary commitment law, which is the Baker Act here in the state of Florida. So there are about 15 specific criteria outlined in the law in the state of Florida that can be considered. Only one of those criteria is severe mental illness. One is solid evidence of substance use, and the other 13 criteria all have to do with current acts of violence, previous acts of violence, and access to firearms or threats to access firearms. So we're talking about behavior, because at the end of the day, the best predictor of violent behavior is previous violence, not mental illness. So to carry on with that, we focus on the behavior. We focus on what we're seeing. And the law in the state of Florida was passed, as you mentioned, in the wake of the Marjorie Stoneman Douglas shooting, which is right in my backyard. You know, officers that I work with had children there that day. My supervisor's child was there that day. You know, half of our agency went there just because we didn't know what else to do. So it's something that struck us it was very close to home. So as a product of that, the ERPO law in Florida the agencies tend to focus on interpersonal violence, and suicide tends to be a secondary function of the law. So to that end, we've had great success in investigating cases that would meet the criteria for risk protection orders. And these are cases that are in that loophole. You know, I understand we have law enforcement here today, people in the state attorney's office, district attorney's office. You all know what I'm talking about when I say that there are those cases where you show up and you see that the writing is on the wall. They're doing all the things that you know are going to lead them to do something dangerous. You know, everything you're seeing is about to break bad, but they haven't quite broken a law. They haven't quite done anything, or you have victims who aren't willing to cooperate, whether that's because they're family and they don't want to see their loved one go to jail, or because they're in fear for their life. So what do you do in those situations? We've had a couple. We had a young man who was behaving strangely. Mom got him to the hospital because she didn't know what else to do. He didn't quite meet the criteria for a Baker Act. He disclosed while he was at the hospital that he was upset and there were some people he needed to kill. This is what he says to the doctor. The doctor and the hospital called us. We have a unit in our agency that investigates these specific cases, these threats of mass violence. We were able to secure a risk protection order. We found out that the young man had just purchased an AK-47 pistol, which was on its 5-day hold. So he hadn't picked it up yet. The receipt was in his pocket when mom took him to the hospital. So we were able to stop that sale. We were able to interrupt that violence. We were able to get the young man some counseling. And we learned later that the young man had been robbed multiple times on his way home from work on Friday on payday. And he was upset and he was going to get a firearm to get retribution. That's not an issue of mental illness. That's actually a very rational response, but it's not a legal response, and it's a very dangerous response. So we need something. We need a tool to interrupt that. We've had multiple cases like that. We had a veteran who moved down here from Tennessee, had an ongoing issue, a domestic issue with his ex-wife regarding his children. We intervened. We got him counseling. We connected him with the VA. We took multiple steps to try to intervene before resorting to a risk protection order, and ultimately, that case ended up where we did execute the risk protection order. We were able to confiscate and hold firearms, and he was ultimately charged federally because he continued to try to obtain firearms with the intention of attacking a naval base down in the Keys. So we've had multiple situations where cases of mass interpersonal violence have been interrupted using this as a tool. This fits so many gaps for law enforcement when it comes to public safety, when it comes to gun violence. It's a tool that I am so thankful we have as a state, as an agency, and we have put it to good use since its inception.
I just want to hop in based on some of what you said. A lot of what we promoted too is that officers and judges, anyone involved needs training. And I was wondering if you could speak to that a little bit, because we've gotten, specifically in Florida, because you were one of the first with this new wave of orders for the law to go in place, where it was suddenly like this law was in place and they felt like no one had consulted them on how to carry it out. So I know, like in Washington State and in Florida, they have specific teams who are trained to do it. I was wondering if you could speak to that a little bit.
So in the state of Florida, I think South Florida, where the MSD shooting really struck us, there was an impetus to do this right. There was motivation to do this right, but it was left to individual agencies. I'm lucky that my own agency looked at the law, looked at what it was capable of, recognized that they needed investigators to look into these cases. Because at the end of the day, we still need to present evidence. When we go for our initial petition, when we go to the final hearing, we need to present evidence, clear and convincing evidence to obtain a risk protection order. So that requires investigation, that requires somebody who's gonna weigh the rights of the individual versus the behaviors that they're displaying. So I'm very lucky that in Broward County in general, in my particular agency, there are units of detectives that investigate these cases specifically. As you go further north, and it's no knock on other agencies, but some smaller agencies to the north have not implemented that same policy, and that's because there is no funding. So smaller agencies from counties and municipalities that aren't as well funded didn't have the capacity to implement this law in what I think is its most effective way. That's because the law was passed very quickly. If everyone knows their history, Governor Scott was on his way out the door to become Senator Scott, and he signed this law weeks before he left office as one of his final acts as governor. I'm thankful he did, but there was not consideration made for funding and training. That's been left to our state governing body for law enforcement, FDLE, Florida Department of Law Enforcement. They're catching up. They're starting to offer training statewide, but individual agencies have really led on creating this training and implementing risk protection orders properly.
And I will say most state bills, if not all of them, have no appropriations, but we are pushing on the federal level. So hopefully down the road, we will get something through that'll funnel the funding to states.
Yeah, this is a great segue. I think that it's important to be very thoughtful when we're thinking about, when we're trying to pass these new ERPO laws, and we are learning from the 19 states in DC that have these laws, what is important to go into it, some of the recommendations I listed at the beginning. So Lauren, if you could talk a little bit about, what to consider when passing and implementing ERPO laws, what equity considerations should be discussed, some of these best practices that you know so well.
Yeah, thank you so much, Lisa, and thank you for the opportunity to engage in this conversation. And so with the extreme risk laws, there are just certain things that with every policy we would really consider. And one of those is understanding who are the stakeholders of the respected policy and thinking about what does it mean to understand potential racial inequities that may disproportionately impact certain communities, particularly in the context with extreme risk orders and thinking about the interaction with law enforcement. One of the things we've been really cognizant of is thinking about the historic and contemporary relationships between BIPOC communities or communities of color with law enforcement. And a big part of what we've tried to definitely do is not to make overarching sweeping statements, to make assessments or generalizations around how communities may feel about the law, but as my other panelists have said, that it's very important to think about how we're educating individuals regardless of their background, just so they are aware of the tool. One of the things that we've seen over the years recently is the increase in young Black males who have been committing suicide. And so thinking about that this could be a preventative tool if given access to the tool. So outside of education, it's really a big part of what we want to do is make sure that we are encouraging law enforcement to be trained adequately. Detective Karita spoke a lot about some of the intentional training that is done. And that is a huge part of what we're advocating for, is making sure that these laws are not only being passed, but there is certain funds that are allocated for them to be implemented in an equitable way, which includes training for law enforcement. And then another part of what we definitely would consider as imperative is thinking about the criteria in which people are getting ERPOs for, and making sure that it is objective and not subjective, which is actually the criteria we recommend actually at CSGV and the Ed Fund, can be found in the ERPO report that Lisa mentioned earlier. And another big component is really data collection, because we do want to improve. We recognize that when ERPO was created, we were looking a lot at mental health equity and making sure that we were not stigmatizing those living with mental illness. And so we want to make sure that as we continue to see these laws passed in respective states, that this law is not having disparate impacts on communities of color and having unintended consequences. And so a big part of that is ensuring that there's adequate data collection so we can start to assess and determine if we need to put potential guardrails in place for future extreme risk protection legislation. But again, another part of that is taking the time really to talk to communities of color to really understand if they do have apprehension, what is that apprehension, and taking the time to explain to them the preventative nature of the tool. And a big part of it comes back to the education of recognizing that this is a civil tool in nature, and that's its intended use. And I would just conclude that, like any legislation, we reserve the right to gain more information and make amendments to laws. But a big part of it is acknowledging the context in which we're living in, particularly with communities of color and other communities of underrepresented identities, and then making sure that we're getting adequate data collection so we can assess and see if there's disparate impacts that we need to make amendments to future legislation for.
That is so important. And, you know, these are still relatively new, so I recognize that we don't have a lot of data at this point. You know, we know that they're overwhelmingly used for suicides for older white men. Can you tell us, though, a little bit about some of the other things we know about the data, like where they're being used, how they're being used nationwide, just anything that you've learned?
Yeah, absolutely. Thanks for that, Lisa. On average, as you've said, that we have, for the data that we currently have, we have not overwhelmingly seen disparate impact, but I think a big part of what we really see as a part of our work is to look at the data, but then also make sure that states are adequately collecting the data. But as of right now, we have not seen overwhelming disparate impact, but want to make sure that that is not the case, and recognize that we are still very early on in understanding that we see a big part of the equity consideration not making it just where we want law enforcement to be overzealous in their interactions with communities of color, but on the flip side, because people project that maybe communities of color are not maybe interested in the tool because they interface with law enforcement, that they're not often being educated about the tool. So we want to make sure that right now the data is not showing that there's not overwhelming disparate impact, but making sure that we're not having the reverse of projecting that the tool may not be something of interest to communities of color and they're not aware of the tool.
Great. Detective Karita, I just have a question because we might have law enforcement listening in or other advocates or legislators, and I'm wondering if you can share, any best practices or any advice for getting ERPO in Pennsylvania. How do you get law enforcement on board? How can you get some of these groups that may be a little reticent to commit to this?
So first and foremost, I mean, we've touched on this in reference to suicide, but the best predictor of a violent incident is a weapon in the hands of a dangerous person. And that goes for law enforcement encounters. When we show up at a house, the most likely scenario for our own safety, the most likely scenario where we would have to engage in some type of, lethal enforcement is if the person inside is a dangerous person and is carrying a weapon. That's when we are most often put in those life or death situations. ERPO is and I want to point out there have been a number of shootings that have occurred at police involved shootings that have occurred at people's houses. Their calls for services, patrols show up. I want to point out that the majority of those calls for service, when a shooting occurs, when a police involved shooting occurs, it's not the first call. It's not even the first call that day. That means the officers arrive. They don't have a tool to de-escalate the situation. They don't have a tool to remove a firearm. No crime has been committed, but they know something dangerous is building here and they don't have that tool. So I would say for law enforcement, keep in mind, this is a tool. This is a tool that's going to be at your disposal. This is going to be a tool to mitigate criminal behavior down the road. I'd much rather mitigate those situations, remove the firearm from the situation, and then try to get people into services, try to get through that crisis without having to lock somebody up. Those in smaller agencies, everybody in your town. You don't want to have to lock up somebody that you care about. This is a tool that can mitigate a bad situation before it gets worse. And as far as getting it passed through legislation, unfortunately, the answer to how it passed in Florida is we had Marjory Stoneman Douglas. We had a shooting that called our legislation. They called our legislation to action. I hope to God that Pennsylvania doesn't need something like that to motivate it to push something like this through. But this is a tool that can prevent shootings like that. This is a tool that, when used properly, when cases are investigated, can prevent tragedies like that. So I hope Pennsylvania can see that and push this through before they need a reminder so close to home as we did.
I just want to touch base on that, Chris. I mean, sadly, I hope we don't get there. We have had Tree of Life here in Pittsburgh and was not enough, unfortunately, to get extreme risk protection orders. But I think when we're talking about this violence and how to solve it, we shouldn't wait for another one, and we shouldn't wait for the daily toll that gun violence is taking on individuals here in Pennsylvania. I don't want to wait, and I hope the people listening will help make that happen. But I just can't not acknowledge Tree of Life and the lives lost there.
Of course.
Okay, well, it's 4:45. And I think we're going to start transitioning into the Q&A. There's been a lot of great questions in the chat, and please post more and we'll try to get back to you via email if we're not able to answer them. Dr. Roselle, I'm going to let you answer the first question, which is about the Supreme Court opinion that was issued today. And Mr. Phillips asks about how ERPO might be affected by this decision. So could you please answer that question?
It's a great question. So this is the Caniglia case where a guy was ultimately involuntarily hospitalized. And after he had been taken out of the home, the police then seized the weapons, but they did it without a warrant. And the Supreme Court today unanimously said that's not okay. That, at that point he was safe. There was an opportunity to seek a warrant. And in fact, in his concurring opinion, Alito actually sort of specifically calls out and say, listen, this was just officers in the house for other business who happen to take the firearms. Red flag laws or ERPO laws are something very different, where there's very clear procedures, there's adversarial review, there's a whole structure and process. And so they didn't speak to it specifically, but if Alito's hinting that he's probably going to be okay with it, I consider that promising. And Mark Forsetto with Everytown, who's one of their 2A scholars, reads it in a positive light as well. So.
Great. One of the extreme risk protection orders really became national news in many ways, unfortunately, recently after the shooting at the FedEx facility in Indianapolis. And Todd wanted to ask about that specifically, and that the ERPO law in Indiana, in his memory, though this may need a little bit of accuracy, is that it was too short to implement, or it wasn't used. And so how would that differ in Pennsylvania, and what were the challenges Indiana faced, and Detective Kritas, maybe you can answer a little bit of that, and I can jump in on the PA piece.
Sure. So a lot of, Indianapolis PD has received a lot of criticism, but it seems that Indiana passed one of the first ERPO laws. One of the first, they were risk warrants. As a warrant, it had higher standards of evidence than protection orders, than the domestic protection orders that we're basing ERPO on now, that the more modern ERPO laws are based on. So as such, there are very strict criteria. And if one of those criteria isn't there, then the risk warrant won't go through. So in the case of Indianapolis, it was just kind of a perfect storm of those things not working in tandem. First off, in Indianapolis, it's the district attorney or state attorney who actually fills out the risk protection order. In Florida and in other states where it's law enforcement who asks for it, we have an in-house attorney that works directly with the investigator to fill out that affidavit and to make the initial petition for the risk protection order. I think that connection with the petitioner to the initial order is extremely important. The way it's structured in Indiana is like a case file. So the investigator hands the case file off to the state attorney reads a case file, makes a decision, and that's it. So things get lost when there's not that connection to the implementation. The other issue I saw was, and it's a technical issue, in the case of Indianapolis, when they spoke to the subject, when they spoke to the shooter, after having confiscated the long gun, they spoke with him, and he said he didn't want the gun back. He said he told the police department, "You can keep it. I don't want it back." By doing that, he actually negated one of the criteria they need. They need to prove that the person is armed and that a firearm, and that they are at risk for committing gun violence with a firearm. Once they knew that that was the only firearm in his possession and he gave it up willingly, they lose their standing to ask for a risk protection order under the way that Indiana has structured their law. Newer versions, again, in Florida, we would have the option to make the argument that, okay, now for the next year, we want to block his ability to purchase another gun. Even though he has willingly given up this gun, we're not satisfied that he is through this crisis. We have all this evidence of past behavior and these planning and ideology. So we would have standing to still get a risk protection order. No, it seems like from what I'm looking at, it doesn't seem like anybody did anything wrong in Indiana. It's a tragedy. But the structure of their law had higher evidentiary standards. And it's a good example of why it's so important to have that ex parte order, to take firearms away immediately, to block someone's ability to purchase firearms immediately. And then 2 weeks later, they present at court. There have been cases where people have had a bad sense of humor. There was somebody who posted a picture on Instagram with 2 rifles leading up to the release of the Joker movie. And said something to the effect of, "Give me 2 tickets for the Joker," and posted a picture of him holding 2 rifles. The agency the agency in his hometown got a risk protection order against him. He went to court 2 weeks later and was able to demonstrate, "Hey, I have a terrible sense of humor. I have poor taste. I post things like this all the time. I am not a risk." And his First Amendment right held up. Anybody who knew him knew that he didn't actually mean what he said, even though it was in terrible taste. And they did not get the risk protection order. His firearms were returned to him. So those checks and balances, that process, that hearing with the judge, it works. And it's that final check in that process that protects everyone's Second Amendment rights, even through the ERPO process.
I just want to pick up on two things here. Thank you, Detective Karita. One is, I mean, I think in Pennsylvania, you know, the bill that's as structured now would allow the weapon to still be taken away if it goes through that process, and allows law enforcement, well, we don't have it yet, and family members to make the petition and work through that process. And the petitioner would be part of the process of filling out the form and putting in the information. So one piece of this is we have a more modern version that might solve some of the problems. I think the second piece is just a logical fallacy, honestly. Will this policy solve every instance of gun violence? I have to say no. But what we know from the evidence is it solves many of them. It prevents many of the shootings, and it prevents many of the gun suicides. And, you know, research after research shows that. So what we don't need, what we're not going to have is a law that's going to prevent every gun incident of violence. Like, that does not sadly exist in our world. But what we can have is a policy that saves lives here in Pennsylvania and gives people the opportunity to get access down the road after the crisis is passed to their firearms. And that's the precision instrument that Dr. Rizal was talking about. And that's what we're looking for here. And then we need other solutions to other pieces of this problem. And all those things together will help us reduce the gun violence in the state. So I think we just have to be careful. Also, I want to note too, the question that, like, that we should be careful of just throwing out the baby with the bathwater, or whatever analogy you'd like to use. And
Adam, if I could speak to that, I can tell you firsthand, my firsthand experience is that all of these measures, all of these firearm safety laws that are in place work in tandem. The case I gave earlier, gentleman was brought to the hospital under the Baker Act. He didn't qualify, but they were able to examine him. We got the risk protection order. Firearms were taken away, and the only reason we were able to get take the firearm away without any interaction was because it was on the 5-day wait. So he made an impulsive purchase to buy an AK-47 pistol, and because it was on a 5-day wait, because he was Baker acted and held temporarily, and because we were able to get a risk protection order, all three of those measures worked in tandem to mitigate that particular crisis. So it's another tool, it's another layer, it's another thing that helps protect the public from gun violence.
You know, and here we are in Pennsylvania, a high gun ownership state, relatively lax gun laws. You know, it's Florida, Texas, and Pennsylvania. We can hold our own with y'all down south. So, but again, here we have an opportunity for a precise, narrow intervention that allows us to get left of bang and potentially scary cases, to do that investigation, say, he's a smartass with a bad sense of humor, versus, an actual threat. Limited impact on Second Amendment rights, knowing that we're going to need a whole tapestry of interventions to really move the dial on firearm injury prevention. But at least this is one nice focus tool that it's not going to infringe on a lot of rights. It's going to let us say this one person, for these specific reasons at this specific time, we are concerned about.
Exactly. And I think some, a panelist asked a question about, what do you say, or a participant asked a question, what do you say about people who just want to use an ERPO to get out or get even with an individual? And so, Taylor, I know this is something you've come across in your work. What protections are offered? Is this really something that anyone can just use at any time for any reason?
No. And I want to start by saying, so we've worked on this in states like North Dakota, which is even kind of more conservative, more rural, and we've gotten a lot of pushback. And that was by far the main talking point I ran into when I was there. And I do want to say in many cases, it's disingenuous. And so if you're going to use facts, you can only get so far with people. However, there are people who really do feel that way. We've gotten that from a lot of volunteers who have an ex-husband or an ex-boyfriend that they feel like that would put them in danger of that. And so, not only is there no evidence that I'm aware of to show that that's been an issue in any of these states, and then B, there are, most of the laws at this point now do have that if somebody falsely files a petition, that there are consequences in place by law. It really varies depending on what state you're in, like what type of misdemeanor, whether it's a fine or you can face jail time. It's kind of really up to the state. But I will say, even though we are just coming from the suicide prevention aspect, even AFSP does not support bills that don't have something like that in place. And I will say at this point, I can't remember the last time we saw a bill that didn't. And for those that did, we made the recommendation and the change was made. It's usually just an oversight. It's not that anybody wants these to be used. And I also want to emphasize what Chris said. There's a lot of people involved in this. It doesn't just go, it's not like I can walk up, file a petition with barely any evidence, and then the judge makes a snap decision and that's it. There's police officers involved, law enforcement. You have to prove that they have possessions of a firearm. There's standard forms they have to fill out when they file the petition. It's not like they're just making a baseless claim. So I want to really emphasize that as a suicide prevention group, we also consider those due process and concerns.
And just to pick up on the Pennsylvania law specifically, I just want to touch on it. Under the Pennsylvania law, filing a false ERPO, right? Maliciously filing a false ERPO is a criminal act, is a misdemeanor. You'll have consequences for it. And I remember, and I'm going to call on Dr. Rizal quickly to touch on this, because I feel like when we were talking last week or two, you had some statistics around actually false or, ERPOs that either weren't implemented because the evidence wasn't there, or, I think one case of a misdemeanor. And if I'm remembering that right, can you recall those statistics? Or am I going to put
I'm embarrassed to say I cannot, but I can certainly attest to the fact that if you're ever in front of a judge and you lie to them and they find out, they get very cross. And that may be the consequence right there for it if people lie to infringe on someone else's rights.
Got it. Thanks. We have time for one last question, and I want to ask it from Tracy, and maybe Chris, you can start it, and then others can chime in. But the question is, what is the rate of those who would benefit from extreme risk protection orders versus gun violence that is from criminals, right? So gun violence is just from criminals. And we've really been focusing on the suicide and mass shooting aspect. So how do you think about extreme risk protection orders within those different parts of the problem?
So I don't have a particular rate or numbers, but I think I understand what the question is getting at. I can say that in Florida, and in my agency in particular, our focus has been interpersonal violence. That's criminal violence. That's one person wanting to shoot or kill another person, and that's been our focus when implementing risk protection orders. I can say that it's actually been a successful tool in mitigating street violence that doesn't have when all the other tools have been exhausted. Broward County Sheriff's Office, one of the first convictions in the state of Florida for a violation of a risk protection order, he was a gang leader who had shot a friend. The friend initially identified him. He was arrested, and then the friend recanted, so they lost their case. Well, they were able to review the last 12 years of cases. He was involved in multiple shootings. They were able to bring in witness testimony for all those shootings where victims didn't want to be a part of the proceeding, and they were able to obtain a risk protection order. That criminal refused to give up his firearms. They were able to prove he had firearms, and he was ultimately arrested for violating the risk protection order. What I like about this tool is that's what it is. It's a tool. It's not targeted at one particular situation or type of person, for that matter. It is a response to violence, and to the most lethal type of violence, and that's with a firearm. So whether that's violence directed at oneself or violence directed at another person, this tool is so incredibly valuable. It's going to be valuable to law enforcement there in Pennsylvania. It's going to be so valuable to family members of veterans who don't want to get law enforcement involved because they don't want to escalate a situation, but they want to intercede on a family member's behalf. It is a tool that fits so many situations.
Great. Well, we are at 5 o'clock. I know there were a lot of questions that we didn't get to answer. And so I would just encourage anyone listening who still has questions, please reach out to anyone here, certainly to Adam and myself and our organizations. We're happy and really eager to answer this because we have seen how well this is working so far. We've seen how many states have adopted this so far. Like I said, almost half the states have it. The other half have introduced legislation, and we can't solve all forms of gun violence with one policy, but we know this is an effective policy. And we really hope that this will become law in Pennsylvania as soon as possible.
Yes, thank you everyone for joining us in our excellent panel. If you listen today and you haven't gotten engaged in an effort to pass extreme risk protection orders, whether you're law enforcement, a citizen, a legislator, someone who works in the field, we need your support. I think what it's going to take is the recognition that this tool has so much value to Pennsylvanians in so many different ways, and that can help us save lives and step up. And so that's why we need you to be sending that message. So, Lisa is exactly right. Please get in touch with me and the team at Coalition Stop Gun Violence and our amazing panelists today, so you can figure out how to take those next steps as we continue to educate Pennsylvanians and move forward so we can implement the same tool here in Pennsylvania that's been so effective in Florida. So thank you, everyone.
Thank you.